but logically speaking, why does it have to be individuals or officers? Why couldn't you, for example, say that a school district, schools that take federal money, if they do, and we want to, why couldn't liability extend, say, to parents who choose to send their kids to those schools? Let's think about, like, if a child is transitioning, say, and the parent says, you know, no, I'm not going to facilitate that. I'm not going to call the child a different name or call the child by different pronouns. Could there be some sort of cause of action that would allow, say, the child to sue the parent for civil liability? Why does it have to be an officer or an employee under your theory?
But because of the consensual contractual nature of agreeing to work as an officer for a federally funded program.
That point.
Right. And so I think when you're reaching a member of the general public, which is what your hypothetical is talking about, it is a totally different set of questions that we're not remotely touching. I think that's what Sabry gets at, is how far can Congress go into reaching members of the general public? Those are hard questions, and we're not asking you to go anywhere near them.
And why doesn't your logic require it? Because you want to rely on the contract analogy for that point. Like, you're just sticking on the contract road.
Because of the contract road, and they admit the condition applies to them. And it's because of the contract, because they've agreed to take the job subject to this condition. And we know that that's voluntary all the way down, right? The state is voluntarily accepting the funds. They're voluntarily taking this job. A person who takes this job might want to demand higher wages or indemnity or things like that, but that's already the norm for them, and they already provide the, you know, indemnity is the norm in Louisiana law in most states.
What about other contracts, though? I mean, what if you, you know, contract for services with the hospital because you're a patient? What if you contract, I mean, I guess I don't understand why it has to be an employee.
I think the piece about being an employee, and this is what's picked up in Russ versus Sullivan and Alden versus Maine as to state officers in particular who also take an oath to comply with the federal constitution and laws, is that you are sort of taking the job sort of subject to the conditions, the sort of terms that attach to the work. It's different than being just like a stranger to the counterparty in a contract. I know that in Hess, United States Marcus X. Hess, that's a situation where you're reaching somebody who's a subcontractor through the sort of a chain of privity. And so the court has addressed that in some other cases. But again, I think this one's easier because of just the nature of the work.
Okay, speaking of the layers of consent, this is just a technical question. The Fifth Circuit talked about the warden and the Secretary of State. Were the guards actually defendants? Because here, are the guards before us?
We don't have their names. They're John Does.
The John Does, but the Fifth Circuit didn't talk about them. The Fifth Circuit talked about the warden and the Secretary of State, saying they couldn't be sued in their individual capacities.
The warden is I mean, the factual allegations in the complaint involve the warden specifically.
Okay, and so the warden knew. Okay, so the Does are not before us. It's just
no. The Does are before you. We don't. You know, it was dismissed.
Right.
We don't know who they are. Yeah.
Okay.
We don't have their names.
And in terms of layers of contract, is the contract with the state of Louisiana or with LDOC or with the prisons?
So the way RLUIPA works is the Department of Corrections.
So it's LDOC. That's just yeah. I just wanted to understand how that worked. Thanks.